My name is Larry Chartrand, and I'm happy to introduce our keynote speaker for today's luncheon. Before I do that, I was asked to say a few words about the Métis Treaties Project, which is one of the sponsors for the conference, and I wanted to let you know about the project because it's an important 5-year research study. And there is a website devoted to the project called métistreatiesproject.ca. And the study is about examining the historical presence of Métis treaties that a lot of people are unaware of. There is a history of Métis entering treaties. It's not well known, but there is a history there, and there is an ongoing process of Métis entering into treaties. And the treaty model is an important one for the Métis Nation to consider, given the fact that we are a nation and we are entering into nation-to-nation arrangements with the government, and that we need to the government, negotiating with governments, Hudson's Bay Company, etc., and looking at moving that agenda of treaty making forward. I just want to mention who's on the research team. You're familiar with a lot of them, I think. Professor Adam Gaudry, Professor Darren O'Toole, Professor Catherine Bell, Professor Sebastian Gramont from the University of Ottawa, Professor Darcy Vermette, Professor Natalie Kermol, and last but not least, Professor Brenda Gunn, who is our keynote speaker today, who is from the University of Manitoba at the Faculty of Law. She asked me not to read her bio because it is already a lengthy one in the fact that her career is really just starting off, and she's already made significant contributions to the scholarship and to thinking about Aboriginal rights. But I do want to say how important it is for our people to work in the area of international law. And Brenda has begun specializing in that area and has looked at the principles of international law and how they apply to Indigenous peoples, and in particular the United Nations Declaration on the Rights of Indigenous Peoples, and how they apply to us as Métis. And it's often a source of rights that we often sometimes neglect. One of the things I was kind of critical about with respect to Thomas Isaac's report, although it's very good in a number of areas in terms of recommendations with respect to process within negotiating rights under Section 35, he ignores and in fact disregards the United Nations Declaration on the Rights of Indigenous Peoples, and I think that's unfortunate. So I'm very happy to welcome Professor Brenda Gunn, who is addressing that issue of international rights of our peoples and letting the government know that you're falling short on fundamental human rights as they apply to our people. So welcome, Brenda.
Hi, good afternoon, everyone. Thanks, Larry. I'm really excited and honored to be here today. It's been a year since I've been in Edmonton, and fortunately the weather is much better this January than it was last year. It's been a really exciting couple of days, and so I'm hoping my thoughts contribute to the conversation, but the conversations that have been happening so far have really stretched my own thinking, and so some of my thoughts that I'm going to present today are a little bit in flux as I reflect on everything that people have presented so far today. But I did want to start by thanking the organizers for bringing me here and for answering all my little annoying questions in very prompt emails, which was really helpful. And also acknowledge our elders and leaders in the room. And thank you for all your comments. It's always really helpful as a researcher to get the direction from elders, to know where you're heading in the right direction and where you might be missing a little bit. And so I really appreciate the reminder that we as Métis researchers need to ensure that we're engaging our communities and that we're talking to our elders as we continue on to do our work. And I think I'm really fortunate because my family is from the Red River, and so I have the pleasure of working at a university institution that is located within my family's traditional area. So it helps to sort of keep me grounded that my mom and dad are in my lives on a very regular basis, and my own community is with me when I do my work. I also want to acknowledge my SSHRC research partners that are in the room, the other treaty project team members. They too have really helped develop my thinking, and I'm really excited that one of my research assistants was able to join me on this trip. I think we've both learned a lot. So what I want to try to do in the time that I have today is to start thinking, as Larry indicated, how the Daniels decision aligns or fails to meet some of the standards set out in international law. And I want to say that we've had a lot of debate and discussions about what Daniels has said. People are talking about the case, both from sort of that legal standpoint, what did the court say, what did the court mean, but also thinking about how it's been taken up. And I think both of those aspects are particularly important, particularly as a lawyer and as a law professor. I sometimes forget that the law also has that real impact on people. And as we're thinking about the ramifications of law, it's also really important to think about how are people taking up the law and how does that shape the law moving forward. So I'm going to start by talking a little bit about some of the international law definitions of who is Indigenous. I'll talk a little bit about the Daniels decision and from my perspective what's going on and what might have been some of the concerns underlying the case that the court mentions. And then I will sort of try to do a bit of a comparison of where I think Daniels is failing or meeting various standards in international law. And as my last sort of opening comment, I just really want to be clear that I do think Daniels is a win. I think it was a really important case, and it was one that needed to be brought. And I'm really excited that we had such a strong leader that was willing to take on that stress of bringing the case forward. But I do think that it's important, even when we win, that we analyze to what extent did we win and what are the ramifications of that. And so that's part of the process that I want to engage in here, is not to undercut sort of what was an important decision from the case, but to start stretching how far does that win go. So I wasn't sure how familiar people would be with the UN Declaration on the Rights of Indigenous Peoples, so I thought I should start perhaps by providing a very brief background. The UN Declaration is a resolution of the General Assembly of the United Nations that was passed on September 13, 2007. So if you're not familiar with the UN process, the General Assembly is the main deliberative body. We could think of it like the parliament or a legislature, right, where every state in the world, recognized nation state, has one seat and one vote. And so when different issues come up, they pass resolutions, etc., and then every state has that opportunity to make a vote. The picture that's up on the slide is actually from the General Assembly room the day that the vote took place. And it's been, you would never know this, but it's been renovated to look the same that it did in the 60s and 70s. So we just have new plush green carpet and new fancy gold background. So this is actually new, even though it looks really old. The other thing about this picture that's really interesting is each of those sort of green lines, you can't read them, but those are each the name of a nation state. And if you can notice any of the colors up there, you can see 4 red dots, somewhere around 17 yellow dots, and then a whole bunch of green dots. So what happened after the negotiations were completed on the UN Declaration, it goes to the General Assembly, each nation state is sitting in a seat with a placard with their name, and they have a little panel in front of them with 3 buttons, red, yellow, and green. And each country then, if they vote in favor, they push the green button. If they are abstaining, meaning they're sort of neither for nor against, they hit the yellow button. And if they're voting against whatever they're voting on, they hit the red button. So this is a picture that someone took in attendance that actually captured the vote on this screen. So as a declaration, as a resolution of the General Assembly, it's of a different legal character than other international human rights treaties. One of the critical differences is that declarations are not signed and ratified. So we, as we engage in the UN Declaration as an international human rights instrument, we should never talk about Canada signing or ratifying it, because they can't. Declarations do not provide an opportunity for individual states to sign and ratify. So specifically in Canada, the only chance Canada had to influence the legal validity of this instrument is with its vote. So while Canada voted against the UN Declaration in that General Assembly, it's just like the legislature, right? If you vote against a piece of legislation and that legislation passes, you are still bound to follow that law. You cannot use the excuse, well, I voted against that, legislation, and so it doesn't apply to me. No, that's not how it works, right? So the UN Declaration entered into effect as a legal instrument in September 2017. Because it's a declaration and not a human rights treaty, like the Convention on the Elimination of Racial Discrimination or the Convention on the Rights of the Child, because it's a declaration, it also is not technically binding on its own. What does that mean? My simplest explanation is that you cannot go to court and have the only sort of claim being made that a state has violated the rights set out in the declaration. But just because you can't go to court and use that as your only claim doesn't mean that the UN Declaration doesn't have legal relevance or effect. Canada, as a member of the United Nations, is obligated under the UN Charter to uphold all of its human rights obligations. And so where's the easiest place to turn to find Canada's obligations in relation to Indigenous peoples? Lo and behold, we have the UN Declaration on the Rights of Indigenous Peoples. And because it's also a very recent document, it becomes really helpful. We can also think about how the UN Declaration relates to other international human rights instruments. I don't have time to give you like a whole lesson today on all of the international human rights instruments and how they all work together, but it's fair to say that there's lots of provisions in the UN Declaration that mirror and reflect and work with other binding international human rights obligations, right? So we also, when we talk about using the UN Declaration, we like to contextualize it in that broader history and the broader world of international human rights. And so I will, during this talk, make a few references to some other international human rights norms. One of the reasons that I engaged in the process of participating in international governance and the UN Declaration in particular is because of the way in which Indigenous leaders from around the world took the lead at every stage of the game and were able to articulate the rights, fundamental human rights, as they understand them according to their own legal traditions and customs. And so throughout the UN Declaration, you see references to the rights being inherent rights. Right? The UN Declaration isn't about the UN giving rights to Indigenous peoples. It wasn't until 2007 that the UN recognized explicitly that Indigenous peoples have rights that are grounded in those traditions. This is one that I particularly tell when I'm doing government training on the UN Declaration, but it's important to remember that the UN Declaration sets out minimum standards. Right? So that's the bare minimum Canada and other states need to meet in order to sort of uphold their basic obligations. It's not as good as it gets. It's the bare minimum, right? So we can choose, and I hope we aim higher than the standards set out in the UN Declaration, but these are the minimums that we expect states to uphold. It was also really groundbreaking for international human rights because it's the first instrument that specifically recognized that human rights can apply to collectives. Another way of saying this, they recognized that some human rights are collective in nature. And so very specifically now we have a shift in international human rights law that some human rights are held by collectives, Indigenous peoples. And so throughout the instrument, you see reference to the rights being held by the people. Finally, I will spend a bit more time talking about this. The UN Declaration does not actually define who is Indigenous, nor does it provide any sort of criteria or indication of who is Indigenous and who can exercise the rights under the Declaration. It was done for several reasons, including the point that the United Nations did not want to enter the business of defining who is Indigenous. They recognize that that's a task to be undertaken by Indigenous peoples themselves. It's a really broad instrument. Has anyone ever tried to read it? It's got like 46 articles, 24-ish preambular paragraphs. It's pretty long. Covers a whole broad range of things. I'm not going to cover all of it today, but it has some foundational rights, talks about equality, non-discrimination, self-determination, talks about life and security, so a right to belong to an Indigenous people is part of that right to security, talks about self-government and autonomy, lots of references to culture and language rights and needing to protect those. There are political and economic rights, a whole bunch of provisions related to the rights of Indigenous peoples to their traditional lands, territories, and resources. There's provisions that relate to treaties, agreements, and other constructive arrangements. That's a category. I've learned to say that very quickly. Treaties, agreements, and other constructive arrangements. So those are all protected under the UN Declaration. So it's a very broad instrument that covers a lot of aspects. But what I want to start to do then is think about if the UN Declaration doesn't define Indigenous, is it useful? Or how do we start engaging in this process? And so this is one of those first aspects that we can see that it's important to understand how the UN Declaration fits within that broader international human rights framework. Because it's not like we have no definition in international law. We just don't have it specifically encompassed in the UN Declaration. So one place that we could turn to understand who are Indigenous peoples is the Working Group on Indigenous Populations. This was one of the first UN groups that worked to define the rights set out in the UN Declaration. And so in a study that they did in, I'm terrible with years, it's somewhere mid-'80s, they started looking at, well, who are the Indigenous peoples? Because this was something particularly that a lot of states were wanting to have set down. So what they talked about at the working group is that there's several indicia that you can look to, including that Indigenous peoples are peoples who have occupied and used specific territory in a time period prior to colonial governments and colonialism occurring. Indigenous peoples are also peoples who have voluntarily perpetuated their culture. This could include language and all sorts of different aspects. So it's not that the sort of culture has magically continued on, but there's actually concerted efforts to perpetuate that community culture. From this very early definition at the UN, self-identification was mentioned as a key component to understanding who is Indigenous. And it was recognized that self-identification doesn't just happen at that individual level, but there's also a recognition by other Indigenous peoples of who is Indigenous, right? So that there's processes that exist formally and informally around the world where Indigenous peoples are recognizing each other. There's also, they recognized processes where states also recognize Indigenous peoples, right? And so we could think in Canada very simply, we have one starting point would be Section 35 of the Constitution Act 1982 that recognizes Aboriginal people being Indian, Métis, and Inuit, right? So we have some limited recognition in Canada. So that might be one other way to look at it. There's also within the definition here a discussion about an experience of subjugation, marginalization, dispossession, or discrimination. So those were some of the early factors that the UN started using when thinking about Indigenous peoples. But I think we can probably all appreciate that's a pretty rough definition and may or may not help us address some of the concerns that are coming out from the Daniels decision. And have I really talked that long already? Jeez, I'm long-winded. Okay. I'll pick up the pace soon. I'll just talk faster. We're not going to cut material. I'm just going to talk so much faster. And Adam's giving me a look. Don't, you're already talking way too fast, Brenda. Another really important human rights body that has developed some amazing jurisprudence on the rights of Indigenous peoples is the Inter-American Commission of Human Rights. And they actually in the last year passed a declaration on the rights of Indigenous peoples as well. So I've got up on the screen a whole bunch of the how the Inter-American Commission is approaching the question. And so for the Inter-American Commission, self-identification is the principal way to identify who is Indigenous. Okay, so the starting point for the Inter-American Commission, self-identification. But they talk about this both at the individual level and that there's a collective aspect to self-identification. So it's not just about individual Indigenous peoples identifying as Indigenous. It's also about a collective, a group of people working together to identify as a particular Indigenous peoples. And they talk about this collective self-identification for Indigenous peoples is always intimately connected to a particular territory and having a special relationship and connection to land. So Indigenous peoples are not sort of just, having an ancestor. What they're talking about here, I think, is that people, and I think Adam's talk spoke a bit about this last night, and I think in a dinner the other night, Elmer was talking about this. And so one of the things that I thought was worth highlighting here is the fact that identifying as Indigenous has this connection to a place and a special relationship with that place as a key indicator under the Inter-American system. They also talk about a need for the cultural identity of Indigenous peoples being shared by all of its members, so having that shared cultural identity. And interesting, in one case, the Inter-American Court of Human Rights talked about that some members may live with less attachment to the cultural traditions than others. But this does not mean that Indigenous peoples lose their identity, conferred upon and recognized by international law. So they recognize for that, for Indigenous peoples, there is that connection to place, but that through various processes, people may have more or less of a connection, but that may not undermine the rights. So that's Indigenous. There's some references to peoples, and I threw in this slide after Mr. Belcourt made a mention of peoples yesterday, and this is how the presentation has spiraled a little bit with all that I've been taking in, is a recognition that Indigenous peoples, under international law, as peoples will also have some particular rights, the least of which would be self-determination. And so we have some broad understandings of peoples as well. So the question I think that we can start thinking about is, do Métis peoples fit under these general international law understandings of peoples? And I think for me that's an easy yes. What might be more interesting or relevant for today's conversations or this weekend's conversations is how do these international understandings align with what the court was struggling with in Daniels? And so I think we've already highlighted this, but it was also important for my own process thinking through. I want to highlight paragraph 17. The court says that there's no consensus on who is Métis. And they recognize that some people have invoked the term Métis to refer to mixed ancestry, and others are referring to, Métis of the Red River or Northwest or the Plains or what have you. The court says we've also recognized in other cases that Métis are distinct. People have talked about this. And then the court, as many people have highlighted, have said that there was no need to delineate between mixed ancestry and Métis communities for the question that they were determining in the Daniels decision. So what I've been trying to figure out and I've been thinking about is, why was the court saying this? It seemed to be somewhat clear before Daniels who they were talking about. How did they get caught up in this? What was happening? And so from my perspective, I think what the court, and Justice Sabella writing for the court, was concerned about was that she was very cognizant of the fact that colonial policies have contributed to people being disconnected from their communities. And I think from that point, it took her to her next concern, which was that since governments may be responsible for causing some of that disconnect, she did not want the government to escape responsibility for people who have been disconnected from their communities because of that government interference. And since the court states one of the goals of the Daniels decision is to address that jurisdictional wasteland that existed, she wanted to make sure that there wasn't a way to, after the Daniels decision, to think that there were still people left out or in limbo, particularly, I think, in limbo. So I think what she was trying to get at in the decision was that the federal responsibility is quite broad, and that for the government's perspective, it doesn't matter which category an individual falls under, but that the government has that responsibility that they need to stand up to. So with that understanding, how does Daniels align? And I did note that I think even from that sort of perspective of the win that Daniels had, that yes, there is a jurisdiction and we have some of that clarification, we do, I think, as many people have pointed out, there may still be ambiguities of what the court said, right? So, and one of the things I've been thinking about over the last couple of days is, from this international law perspective, is Daniels, how far can we take Daniels in achieving that goal of getting the land back? And so now in my last 2 minutes, I'm going to try to tie this all together.
You got a good half hour.
I was told half an hour, and it looks, damn it, I shouldn't have said anything. I was about to be able to go on for hours and hours here. So how do we take sort of what I've been talking about with Indigenous peoples and what we've been sort of talking about what the court did in Daniels? For me, a couple of key things are popping out. Is that under international human rights law, Indigenous peoples clearly have a right to self-define. This comes through from that very fundamental element of self-determination, the right to determine one's political status, social, cultural, and economic development, as well as that right to self-govern, right? As a part of the right to self-govern, you have a right to decide who you're governing. When we think about this, there are other related rights that include the right to belong to an Indigenous people. So as Indigenous peoples, we have a right to be Indigenous and belong to Indigenous peoples. That Indigenous peoples have the right to determine their own membership and the consequences of that membership. I think sometimes we forget that second part. The rights and obligations and responsibilities of our community members are also part of that right of being able to belong to that people. You can also have the people set out responsibilities. Part of this right to self-define for international law is about also that right to pass along the culture to the future generations. And so part of what we see tangled up in these rights is that right to perpetuate language and culture onto our future generations. So that, I'll leave it there. Importantly, and I think I personally think we can't emphasize this enough, that the rights in the UN Declaration belong equally to men and women. So this right to belong to Indigenous peoples and to define membership applies equally to men and women. And there are particular provisions in the UN Declaration that talk about Indigenous peoples' right to participate in decision-making. That includes a recognition that Indigenous women have a right to participate in those decision-making processes. As I already mentioned, there's recognition that being Indigenous includes a right to your traditional lands, territories, and resources, and that connection to the relationship is critical to perpetuating that culture and for that defining who you are as an Indigenous peoples. The next thing, and sort of maybe the final point before I open it up to some questions, is that from my perspective, the UN Declaration does not just pose obligations on state governments, but also sets out minimum standards for our own governments to meet. And so I expect my own Métis government to also uphold the rights that are set out in the UN Declaration. And so for me, where I get to on this question about did the courts muddy the water a little bit on the definitional issues, and if they did that because they wanted to sort of not let the government off the hook and ensure that the federal government had clear sort of full jurisdiction, it's important, I think, that we ensure that Métis governments now aren't having to pay the price and deal with potential fallout from the Daniels decision by people taking it up in different ways. I'm not sure if I'm clear on this point because it's something that I'm kind of trying to work through, but there seems to be this, if the court was concerned that we don't want the federal government to escape responsibility, and if we think that maybe the court is moving away from a clear definition of who is Métis, and we have a right to self-define, have they just made our job more difficult, right? And so if they have, I think it's also important to think about it's not appropriate for Canadian courts and governments to make the jobs of Métis governments who are defining their people more difficult. Thank you, Brenda and Chris, for nodding there, because I feel like maybe my point got out. That's very muddy in my head, at least maybe came across. So thank you very much. Did I bore everyone to sleep now? You've all had nice full bellies of delicious chili. I'm happy to try to take a question or two.
Thank you. Muriel Stanley Venn from Edmonton. I just wanted to add a point. The news about the Daniels case spread very fast, and especially to my dentist, who thought that I had free dentistry. So I told him, we don't have free anything. So,
Yeah.
Which brings to point of making sure that we retain our own integrity as Métis people, and that maybe, as you were suggesting, maybe one of the things that's happened with the Daniels case that's now become more complicated. But yeah, I was surprised, and you know, when you think of it, the dentist being aware that Métis were getting something. Looks at the exploitation that is happening to First Nations people. You know, it's infamous that they charge more and they do all kinds of things that discriminate against First Nations. And just to think that he thought, oh, goody, here's, another one. So I just thought I'd make that point, and the integrity one, too, that we will not give up our Métis values or for the sake of what. So thank you.
Thank you very much.
Good afternoon. My question to you is that you had stated earlier on in your presentation that the UN supports all treaties, Aboriginal treaties. in the countries that they originate from. In my correspondence with the Canadian government to date, I've been dealing with the Jay Treaty, which you're familiar with. And the response from the federal government of Canada is that they don't acknowledge the Jay Treaty. Mm-hmm. I find that sad that I get treated better in the United States under the Jay Treaty than I do in Canada. And I've been going through the actual process of entering the United States with a simple card and coming back through another border crossing, which has worked extremely well, and I've received nothing but a lot of respect from the United States custom border guards. And I've actually even went to the point of making an application for my green card at INIS in Idaho and my social security number in the United States because I have dual citizenship through the Jay Treaty. I was wondering what process could we initiate with the Canadian government to recognize the UN's declarations on treaties and have them be supportive of the Jay Treaty for that there's not so much confusion. And I have so many coming to me, Métis, saying, Don, we tried to enter underneath the Jay Treaty into the United States. They wouldn't even acknowledge it. And it was based on work or wanting to move to a new location. Yeah. And there's so much confusion out there, and that's why I've taken it on personally to iron out, if you want to use that terminology, the crinkles in the Jay Treaty. But the last one I have to do is to work with the federal government of Canada. And I sure could use your assistance in this regard, if you could provide any, or direction.
Yeah.
Thank you.
I can try to... I can't actually answer that question directly. I'm sorry. I think the question is very complicated. It's not one that I can. Yeah. But what I can very quickly do is talk a little bit from my understanding of why that was, why those provisions were included, and what the hopes were from the recognition. So, my understanding was that, and this is coming both from my work with treaty elders in Manitoba as well as work with and sort of listening to Chief Willie Littlechild talk about his work and why these provisions were included, is a recognition that many of the treaties that were signed between Indigenous peoples and the state were nation-to-nation treaties and were not the sort of sui generis lesser treaties that the Canadian courts have referred to. And so the hope for including in the UN Declaration a recognition of state obligations to uphold all of the treaties that they have undertaken was to promote and have another push for governments to uphold those rights and the treaties. Secondly, they're recognized as potentially having an international character, and the phrase that the UN Declaration uses is being of potential concern, meaning that there has been push from the Miguel report on treaties forward to look at developing some sort of international dispute resolution mechanism where Indigenous peoples can bring their claims against states for failing to uphold treaties to an international bodies away from that domestication of treaties that happens in the domestic treaties. So that's the ongoing work that's happening at the UN level to push for treaties. The challenge that makes your question for me a little bit more difficult is the Jay Treaty is not an Indigenous Crown treaty. It's one between the U.S. and Canada. And so Canada under international law, customary international law, a little bit of Latin for you, Pacta Sunt Servanda, Canada is obligated to uphold all of its obligations. But the failure to uphold that treaty is a dispute technically between Canada and the U.S., and U.S. has never taken it up with Canada publicly in any sort of forum that Canada is failing to uphold that provision. The U.S. also deals with it very differently. It's good to hear you're having good experiences, but from everything I've heard from around the country, people have, depending on which entry, depending who you're from, what community, what your chief from that community might be willing to sign on. It's very different. So I appreciate it's a big issue, but I'm sorry I don't have a specific answer for that legal problem.
Well, thank you for your answer, then.
Thank you. Yes.
Hi. Darcy McRae with Métis Calgary Family Services. There's a couple of points that were brought up after my previous comments that I would just like to add to. I didn't know a lot of that research was going on with the kinship ties, which is fabulous. I'm glad that that's happening. But on top of that, when you're also looking at that kinship and the space they were on, that then gets us into traditional land use and going into the Declaration of Rights of our space, land, resources. Now, the other thing Métis people are known as is the children of the fur trade, and that's sort of how we were born to be in where we're at. Now, the reason for that was the fur was the most valuable resource on Earth at that time. Furs were 4 times the value of gold, and that's why they wanted people out harvesting those furs. The next one, again, looking at traditional land use, the best furs were out here in Western Canada. We then go to what did Canada utilize as their next biggest economic generator, which became agriculture, which came again across the prairies with being the wheat belt of the world. And that was, again, carrying Canada's load financially and contributing to all the benefits that all Canadians get to this day. Looking at then their third biggest economic generator comes into oil and gas, which does now come across Saskatchewan and Alberta. Again, traditional land. So those were some things I think of the UN Declaration of Rights, again, is very helpful to us in that regard. Some of the other things, though, earlier that I did forget to state is that these rights that we talk about, these Métis rights or Aboriginal rights, we're here today and we're looking at these rights as being ours. And clearly these are not ours. These are our ancestors. These are the people who first founded this country. It's their rights. They were denied those. We are now just getting to be acknowledging that they should have been accepted. So again, keeping in mind, these are not our rights. These are our ancestral rights. So I wanted to make sure that we understand that. Now, I'm sorry, I'm going to carry back to the previous presenters because I didn't have a chance to speak. But in terms of the Métis memberships, I certainly would like to support that. And so how would you become authorized to do some of that genealogy or research to support families to be registered? I know you can't answer that, but that's just something I want to know. And then another point I'd like to make would be about how many North American Aboriginal groups are relocated to any other continent. Where in the world are any North American Aboriginal groups relocated into another part of the world? To my knowledge, they are not. They stayed here with their land. There's other people who've migrated here, but I don't know that it's been reversed the opposite way. Just again, as a point to be made. And then lastly, everyone talks about the 3% population of Aboriginal people in Canada, which really diminishes when you're looking at 100%. 3% really looks like, who cares, that's just 3%. But when you do the Aboriginal population across Western Canada, and these are not even including the Métis people who don't know that they are genetically connected to the Métis history, we are almost 20% of the population across Western Canada. We carry a lot of weight around here. If we use it politically, as we can be stronger. And if we align with the First Nations, we can also carry a lot more weight. And so I think that's important, that things that we do going forward and advocating for those rights that are recognized in the UN Declaration of Rights. Thank you.
Thank you for your comments.
Hi.
Question on this side?
Walter from Grand Prairie. I just want to say I really want to thank you for your presentation. I've been following our MNC president on his monthly letters and his visits overseas to talk with different other heads of government and talk with people at the UN. And I know we're working towards a greater goal of recognition for our Métis rights. What I wasn't clear on with the whole UN DRIP thing was, how does that apply to us in the forest? How does that apply to, the environment, the fish and the wildlife? I think some of the points that you made here with Daniels will help enable that. But now, when I submit documents to the Crown or something like that, I will, I have a reference framed to put it in terms of what Daniel's is. What needs to continue is how our rights are impacted by, development, and how that connect. Like I notice other First Nation groups have brought the UN Rapporteur here to Canada to hear their comments. We haven't sat at that table with the UN representative. Maybe one day there will be a requirement to do so, but at least at the present time, on a local basis, I haven't quite figured out, how other than to put it into a report or document, what it really pertains to in terms of the average Métis on the trap line.
Okay, thank you very much for your comments. I have, sorry, let's need a moment to think about how to respond. The presentation that I do a lot, and a lot of the work is actually implementation at the domestic level, so how we actually work towards implementing the UN Declaration. And so I give that presentation about once a month somewhere in Canada. And so this time that was not the presentation I was asked to do. So those are not the slides that are in the deck, and new slides were developed. So I'm happy, and I do that capacity building. I spent some time last year here in Edmonton, a few days working with Treaty 8 staff and doing some workshopping some of this. How do we start rolling it out? I do work with judges on this and lawyers. So I think you're right. There is a lot of work to be done to, one, understand what it is, and then to think about how do we start using that. And I'm sorry I wasn't able to do that today. The second point is that I did develop in about 2013, I think, a handbook on understanding and implementing the UN Declaration on the Rights of Indigenous Peoples, and I printed somewhere about around 6,000 copies, and those have gone, and I don't have funding for more to be developed. But it is available free to download on my faculty website, which may or may not be linked to in my bio that I said, Larry, not to read. So there is a way. The other way is I assume, I've never done this, if you Google Brenda Gunn Robson Hall, and sort of find my faculty page, click under bio, there's a link there that'll take you to it. So there is, and that was really designed to address several different audiences, including my own family. My dad has a grade somewhere between 4 and 8 education, depending on the day. He'll say whatever it is. And so, part of me was also speaking to my dad, but also trying to make something that had enough references and depth for people who are wanting to use it at a deeper level. So that is a resource that's out there. But I'm happy to talk with you at sort of another time about more specific actions. But thank you very much for the comment. Okay.
Thank you very much for the presentation, Brenda, and the questions from the audience. Just one quick note, the Métis Treaties Project is going to have a community conference in the spring of 2018 in Saskatoon, where the results of our research will be presented to community Métis representatives from across the Métis homeland. So just be aware of that. News of that you can find out from me if you want, by getting in touch with me at the University of Ottawa. I'd be happy to keep you informed of that conference coming up. Just one note about the question about the border, crossing the border. There is a provision in the UN Declaration that obligates states to try to minimize the international foreign impact of that boundary so as to ensure the cohesiveness of the nation that crosses the Canada-U.S. boundary. There is some wording to that effect, I think, in Declaration. We have to think about that as a Métis nation, because a lot of our relatives are across that border, and how do we rebuild our nation as a whole? And so just with that, I want to thank our panelist, our keynote speaker, Brenda Gunn. She is actively involved in this area, and I think you'll agree with me that we're in good hands. Thank you.